So
Okay.
there you go, forward. I don't know how to go backwards. So do it that way?
I use a lot of them, so.
Got the little thing in the corner, but.
That's fine. That's okay. Okay, so that we're gonna fly past this. So we know that federal law says that cannabis, except for hemp, is illegal, federally illegal. So what does that mean for the court system? So I'm a litigator. What kind of litigation we have? I want to just do a quick overview of, and then you can ask questions, but we're kind of seeing everything in the world. But it's just complicated because we have the state court and federal court problem and the tension between the laws. So let me see if I can, okay, so the first area, we have tons and tons of litigation, is breach of contract and fraud. Most of them are breach of contract issues, but everybody always includes fraud, right? They got tricked into entering into the contract. They didn't understand what was going on. They got lied to, whatever. So they have a fraud theory. Why is a fraud claim important to people? It's because if they were to win, they could get punitive damages far beyond the benefit of the bargain for the contract. So, but what kind of problems do we have with breach of contract cases? First, a contract can be enforceable only if it has a lawful object. So, under federal law, any contract that involves cannabis is not a lawful, it doesn't have a lawful object. However, California enacted a statute, Civil Code Section 1550.50, and says that a contract involving cannabis does have a lawful object. So under state law, it's enforceable. Federal, that's Civil Code Section 1550.50. So the federal courts, if you go into federal court, because you have to, for those of you who are not lawyers, to get in federal court, there's two ways to get in federal court, and that's diversity jurisdiction, and everybody's citizens of different states. There's a lot of nuances to that, or there has to be involved federal question. And we'll talk about that a little bit as well, federal laws implicated. So you can end up with a breach of contract case in federal court instead of going to state court, California court. But if it involves flower touching, you're not going to be able to stay in federal court. And when I say flower touching, I'm talking about that the remedy that's going to come out of the lawsuit involves the processing, sale, distribution of cannabis. What's happening, what I'm finding is that the federal judges are keeping the cases if it's just about money. So if the parties have a dispute and it's just about where there's an interest in a company or property or something like that, and it's unrelated to continuing violation of the Controlled Substances Act, a federal judge will keep the case. However, if the remedy involves processing and sale and so forth of cannabis or money coming from cannabis, then a federal judge cannot keep the case. Why? Because of the illegality doctrine, and we'll talk about that in a little bit. So you have to focus on what is the remedy. So we'll come back to that in a second. So then, what are the kind of breach of contract cases and fraud cases that we're seeing? We're seeing lots and lots because the industry is in the dumps in California. Let's be frank about it. So a lot of people jumped into the business in 2017, 2018. Outsiders came in, they bought up farms all over the place. When I first started practicing in this area, I thought I'd be doing dispensary work. Virtually all my litigation involves farms. People have invested hundreds of thousands of dollars buying property for millions of dollars. It's now worth, pennies on the dollar, and the farms have failed.
Excuse me, I'm gonna see if I can fix this while you speak.
What kind of problems have arisen? We have people where they're entering into handshake deals. A lot of times with the cultivators have come out of the illicit business in the past. They're not used to dealing with contracts and paperwork and the nuances of all that and their obligations. So we have handshake deals, so we don't have sufficient documentation. And then we have poor drafting of agreements. I've seen more horrible contracts written where there's gaps. And or it's not clear who's obligated to do what. And those end up in litigation as well. And then flawed and incomplete transactions. Well, you have, many of you probably are aware of this, that typically on a cultivation site, you have several layers of companies. You'll have a LLC that's formed to own the land itself. And then you'll have an LLC that gets the license, right? And then you'll typically have a management agreement where the LLC that has the license manages has use of the property and it has obligations to pay rent to the landowner. Sometimes the ownership isn't the same. And so you've got problems where how the money is being divvied up and controversy about that. What a lot of times in these management agreements, the duties and obligations of the different parties are not explained well. And so there ends up being disputes among people about who was responsible for what. I had a major case where the cultivator said, oh, I was only responsible to cultivate the crop and bring the crop in. I wasn't responsible to store it safely. I wasn't responsible for security at the farm at the end of the harvest when the stuff was put in a storage unit and locked up, and then it disappeared. So there's all these disagreements about who is responsible for what. And if it's not spelled out clearly, there's going to be disputes. Another thing that comes up, and I'm departing from the slides a little bit just to make it move a little faster, is that people, sometimes people will hire good lawyers, experience in the cannabis area even, and they'll get all the transactional documents all in order. And then once the farm is up and running, people depart from the documents. They don't comply with the documents. And this one case, I remember they had a well-known firm that we all know and respect that did all the documentation. But once the farm got up and going, nobody was really paying attention to the documents. So we've got poorly drafted transactional documents, poorly drafted contracts that people are entering into, and that's rife for litigation. It gives us litigators a headache because sometimes we don't have the right stuff to work with, and it's a huge problem. On this issue of duties, different people have different obligations. What's the cultivator supposed to do? What are the other people, the owner, supposed to do, and so forth? There's always disputes about that. Who's supposed to pay for what? A lot of times we've got, the story is always the same about the cultivator's given a credit card. The cultivator uses it to go buy a truck. Cultivator goes and uses it for personal items. The cultivator moves his family onto the property, even though the cultivator wasn't supposed to do that. And they're living in a mobile home on the property. And they weren't supposed to do that. And all this, and meanwhile, the owners, the money people, they're living in Ohio, or they're living in Connecticut or something like that. And they're clueless about what's going on in Humboldt or Mendocino or Sonoma until it's too late. And then by that time, the crop has failed or has been stolen and the crap is hitting the fan. So we have lots and lots of disputes like that. Let's go to the next slide. These ownership and investor disputes get complicated also in that, and many of you know this, that if you have an LLC and if it's a manager managed LLC, the manager has fiduciary duties to the others, just like in a partnership. And so you have the highest level of loyalty, and you can't do anything to harm the entity. You have to always advance the entity's interests over your own if you have fiduciary duties and you're a managing member. If there's no managing member and if just members, then they only have duties of loyalty and good faith towards each other, kind of almost like it's more of a contractual type of a relationship. And sometimes that's not clear either. You'll have you'll have, maybe those with the register with the Secretary of State LLC, there's a managing member. But when in the real world, everybody's doing all sorts of stuff. And so there's claims that, well, so-and-so took on duties above and beyond just a duty of good faith. And they had duties that were closer to fiduciary duties. We have problems where people have arrangements where there's silent partners, people that wouldn't normally qualify to have an interest in a cannabis cultivation operation because they're living out of state, or they don't have, and some counties have had requirements that you have previous cultivation experience in order to get permits. And so people will hook up, people that don't have cultivation experience, they'll hook up with somebody that does have cultivation experience, but they'll stay in the background. And then it turns out that their money's at stake and they lose their shirts in it. We've got problems with self-dealing, where the people are selling to their own other companies that might have distribution. And most recently, because the industry's been in such a bad shape in California, I'm seeing more and more clients that are dabbling in the illicit market. So they might, my view is, and I think most of the lawyers that are here, we don't take on clients that are engaging in illicit activity. But then you find out.
None of us are gonna have any
Yeah.
plans.
Yeah.
That's how I work.
Okay, I'll speak for myself.
Didn't you?
My
say Wyatt
engagement,
is,
my engagement letter requires people to be in the legal business. And I don't take on anybody that is not in the legal business. However, what happens is you get in litigation and then time goes on and you find out more about what's going on. And it turns out there might be a section of the farm.
The LA Times might write an article about it, for example.
So, but I don't knowingly represent non-legal businesses as a commercial litigator. So, and then we've got,
Should we pause for a crime fraud discussion?
So then we have
The ethics credits. for this,
yeah,
right?
so, and then going, just trying to work my way through the list, we have problems with defaults on loans and leases where the loans are not getting paid. Or the leases are not getting paid, the property gets taken back by the original owner a lot of times. And now the property isn't worth what it used to be worth. And there's also an anti-deficiency statute in California. So you can't go after somebody else based on the loss in value of the property if the property is secured by a note. So call me if you have a issue with that. Things we're seeing also coming up lately is employment issues, wage and hour claims. All these farms, they've ignored break requirements. They've ignored lunch requirements. They're not giving people, if it's harvest time, they're working 15 hours a day, right? They don't have adequate housing. And so then what happens is they sue, the worker will sue later on. Is there any writings? Is there any good records on how people, what hours people work, when they took breaks, so forth? No, there's nothing like that. And even the clients that have been good as far as keeping, doing pay stubs and doing W-2s and 1099s and all the tax stuff, they still don't keep good records on shifts and overtime and so forth. And why is that? Most of the time it's because the farm is being run by a cultivator who doesn't know anything about this stuff. He or she has never had any training. They know how to grow good weed. Hopefully they know how to grow good weed, but they don't know how to supervise people. They haven't had training as being an employer and a supervisor. And of course, we have situations where we have wrongful termination. A lot of times the owners get sick of the cultivator. They find out the cultivator's been cheating them or whatever, or the crop isn't coming out well, it's got pests. They've used pesticides, secretly used pesticides that don't show up until testing. And the owners say, got to get rid of this cultivator. They terminate the cultivator. And then it's complicated because the cultivator might not be just working as an employee. The cultivator might have gotten a membership in the LLC. That's what was doing, there were a lot of people were doing, and I think they're still doing it with the to get the cultivator on board. They give them a membership in the LLC without having to buy in with them cash. And so then you can't just toss the cultivator out. The cultivator is a member. Moving on quickly. Federal courts will enforce federal laws, generally applicable laws, ADA, OSHA, you name it, the tax laws. The federal courts won't have any problem enforcing federal regulations, even against businesses that are outside of California law, illegal. Moving on, landlord-tenant disputes, they're typical, except they're complicated by the fact that there's cannabis involved. Most times the landlords know that there's cannabis being farmed on the property. Then I wanted to talk a little bit about trademarks and IP. This is a real big problem, right? Because you can't get a federal register, you can't register a trademark with the Patent and Trademark Office if it's flower touching. So people are registering for related items. T-shirts doesn't typically work. Some companies are using educational websites, or they're registering for hemp products, but expressly disclaiming high THC cannabis, right? The problem is by expressly disclaiming high THC cannabis, then they may be cutting themselves out of having those rights going forward, and that's an issue. We're finding that people are getting ready now for rescheduling. Rescheduling, you'll be allowed to register a trademark, but don't forget, if it's Schedule 3, it's for medical use. And I'll let other people talk about that know more about it. So, yeah, so you might end up being able to register a mark for your product, for your brand, but it's really going to be only protected to the extent it's for medical use, not for recreational use. So we're going to have to see how that turns out. People are registering marks with the state registry, but those rights only reach, stay within the state borders. And then we have common law trademark, and that's just the use regular commerce of your mark, but it's what we call Swiss cheese protection, right? It's geographically limited, and to the area where you actually are engaging in commerce. I had an interesting case recently. There was a non-cannabis case that we never really resolved the issue, but the person was had a comic book business, and he had a store in Portland, but he also went to these trade shows, and he had a booth at trade shows. And so one could say, well, he'd established his common law mark in Portland with this name, and so he had that territory under common law. But do trade shows all over the country, do you create some sort of a national presence? And how does that juxtapose with somebody else who's using the same mark on eBay or on Amazon Marketplace and so forth? And that has not been sorted out by the courts, believe it or not. This issue about just because you're selling something on the internet, does that give you national common law rights? So it's still to be determined. How do you protect your IP? This is an issue now in the patent space. I have a case right now that's pending in federal court in Los Angeles involving extraction equipment. And the company that holds these patents, called Gene Pool, they claim that these extraction equipment developed by Extraction Tech Solutions, I think it's called ETS, that their equipment violates patents that they hold, and they've sued in federal court. In contrast, the trademark, where you can't get a trademark for something that has an illegal purpose under federal law, patent law is agnostic. Patent law, you can get a patent on an invention that is conceivably can be used for illegal conduct. So the patent office will give a patent for equipment or plants or whatever, or methods that perhaps could be used for illegal use. So then the question is, how do the federal courts handle that? Because patents are exclusively protected in federal court. There's the jurisdiction for patent disputes rests in federal court. So in the gene pool case, I'm actually representing Halo, which focuses on vape cartridges. They bought the equipment from Extraction Tech, used it in Oregon and in California, and they got sued by Gene Pool, even though they're just essentially Halo was a consumer of the product, getting the product and then using it to make the oil for vape cartridges, and didn't have anything to do with the design of the equipment or even the installation of the equipment. But the question is, so what we're trying to do is we're trying to get the case dismissed because we don't think the federal court should have jurisdiction over it. And why is that? Because the only relief that the court can give in a patent infringement case is an injunction or a royalty, right? Well, where's the royalty going to come from? The royalty would necessarily come from the processing and sale of high THC cannabis. So the judge, we filed a motion to dismiss. The judge denied the motion to dismiss, saying, well, conceivably, this equipment, this ETS equipment could be used for medicinal cannabis, or it could conceivably be used for hemp. And the patent itself doesn't even read on cannabis. It could be used for essential oils like lavender and so forth. And so the court says, as a matter of pleading, the initial stages of the case, that I'm not going to dismiss the case because the equipment could conceivably be used for legal uses. So now what we're doing is we're getting ready for trial, and we're going to bring a motion in limine, which is a motion to exclude evidence. And we're going to say to the judge, you can't award any jury, and you can't award any damages in the form of a royalty or even issue an injunction, because what it does is it implicates a substance that's outlawed by the Controlled Substances Act. So how can a judge, so think of it in terms of this old case in the 1730s called the Highwayman's case. And in the old common law case in England, two guys were holding up stagecoaches, and they had a fight over the splitting of the money that was stolen on the stagecoaches. And the court threw the case out and says the courts are never going to entertain disputes where they have to divide up ill-gotten gains. So it's the same thing here. So if you got a patent case and there's the remedy is a royalty, the only way the royalty can be paid is if it's with high THC cannabis, doesn't fall within definition of hemp. Then so under those circumstances, the court shouldn't be able to provide the plaintiff in this patent case with any remedy. The counter argument is that's not fair. The federal government gives us a patent. Why shouldn't I be able to enforce my intellectual property rights in a patent? And for the courts to slam the doors in my face after I obtain a patent from the federal patent and trademark office, that's not fair. That's not equitable. So anyway, we're going to see how that turns out. And I think that's it. And I'm going to turn it over to Dana now.
Question. So there's a lawyer letter from a DC firm going around to dispensaries saying that they have trademarked a use of the words liquid diamonds.
Okay.
Have you seen that? And that's everywhere. And my retort to that is it's a common usage, but I do have a copy of the California license for them, saying it's been in use since 2021 as a scam. So it looks like at least 3 brands right now use those exact words on their quote unquote unpermitted packaging. How do you approach responding to that? I represent retailers specifically, and the demand is remove everything from your shop. that has that, because they're infringing on trademark. So
What trademark are they claiming? A federal trademark?
Well, it's a state of California's stamp trademark that
A
says.
state trade, a register?
This company, Accretion, I guess,
Uh-huh.
owns the words
Ascension.
Ascension, that's it, owns Liquid Diamonds.
Okay.
And it's these three brands that we know of have that on their label. And they've licensed it to Gold Drop.
With that.
Okay,
Licensed it to Jeter as well.
Yes,
I had a
exactly.
client that was using that mark and they got a cease and desist.
well, I can't get legal advice today, but when you apply for a federal trademark, that trademark is vetted, right? And it has to vetted, it has to go through a process where it's examined by trademark examiners in Washington. And then it's ultimately published and you get registered, and then you have presumptive rights throughout the country. California, when you register a trademark in California, it's a rubber stamp situation. It's not something where there's an evaluation done by the state of California as to whether it's a valid trademark or not. So what I would do in that circumstance is I would challenge the validity of the mark itself. And I would say, well, doesn't meet the qualifications for protection because it's in common usage, or whatever defenses you might have for that against that mark. I'd raise them in California in a California court, because you can't, just because they got a mark registered in Sacramento, that doesn't mean it's the end of the discussion. They still have to show that at the end of the day, they have to show that it's enforceable mark. It has all the requirements to be enforceable as to cannabis or whatever they're claiming it.
Do you know what their remedies are in the case of a California retailer selling products that they haven't licensed for the particular use that they assert is valid of those words?
I'm not sure I'm following you, but what they would have to do is they would send you cease and desist letter, like you said, and then they'd have to file an action in state court for an injunction, right? And so and then they have to, then what you do is you hire a good lawyer that's gonna fight the injunction and establish that it's not a trademark that's enforceable. And you have a whole list of defenses you can raise.
That's a process that not many retailers are going to want to go to, so it sounds like even in that case, the measured damages is, well, I guess it's disgorging the profits. But you're right, if you have to have a court affirm their rights, that's a process they might not want to go through.
Well, that's right. Just like the ADA, all the lawsuits about ADA, right? So everybody got sued because they didn't have the proper ramp in front of their store. So they paid $15,000 to these different firms. They go around, that's their industry, is they go around and they shake people down for relatively small amounts of money because they don't want to hire lawyers and so forth. But in this case, this situation, again, I don't know any of the facts. The companies that are using the mark on their branding, they could conceivably have claims against the people that are claiming the mark. If the mark's not a valid mark, it's not enforceable, then they might have claims for interference with contractual relations and unfair business practices and so forth, because what they're doing, this party that's claiming a mark that isn't really a valid mark, they're interfering with their business and getting retailers to pull the product off their shelves when it shouldn't be pulled off their shelves.
And just to close the loop, are you suggesting that a court would have to order that or verify that that is a valid mark? That's not, that rubber stamp you described is not enough?
If you got a good lawyer, the court doesn't do it on itself. The lawyer has to bring it to the judge and essentially establish through a motion for summary judgment that it's not a valid enforceable mark for whatever reason. And then there's a number of different defenses. So to generic, right, common usage, and then who's a senior user, there's always a dispute about the senior user. And that's another interesting, before I sign off, that's a very interesting issue is on trademarks is senior user. So normally in the law, the first person to use a mark is the person who has the rights, right? However, if it's illegal activity, you're not gonna have rights built into it in the federal context. So there was a case involving Kiva, where the two companies and, Kiva confectionaries, and then there's Kiva, another company called Kiva. And they ended up in federal court, and Kiva confectionery said, well, we've been using the mark since date A. And the other company came along and they're not in the cannabis business, but they were using it since date B. And so the federal judge in San Francisco, Judge Breyer, actually excellent judge, he said, Kiva doesn't get any benefit. Kiva confectionaries is no benefit for the senior usage that predates the legality of cannabis under federal law. Do you get what I'm saying? Is that earlier time doesn't count. So when we do get to a point where we can get federal trademarks, the fact that you had a cannabis business and you were using a mark that was legal under state law, say in California or Michigan or New Jersey or whatever, isn't gonna give you any benefit as a senior user when you go to Washington and try to register that mark. So all these people that have similar marks in all these different states around the country and the different local markets, when trademark registration becomes available in Washington DC, everybody's going to be racing to the PTO to register, and they're going to have very similar marks, and the PTO will not give credit for prior use that was illegal under federal law.
You also want to look very, very carefully at their claim. When we first drafted 215 and we're getting signatures and stuff, we had the Red Cross with a green arrow on it. We got a cease and desist letter from the Red Cross. Telling us we couldn't use the Red Cross. And I looked very carefully at what they had trademarked. And I believe they had the Red Cross on a white background, and we had it on a tan background or dated background. Wrote back and I explained the difference. They never bothered us again.
Yeah.
Go real carefully at specifics.
Oh, yeah, trademark law is very nuanced. It's always best to have an excellent trademark lawyer, and there's several in California. We're fortunate to have some really good cannabis trademark lawyers available. Mary Shapiro, we all know. And there's others that are in this space that can really give good advice. I've one more story and then I'm gonna turn it over to you.
Okay, but we are,
Running out of time?
we were
Okay.
supposed to end in about 20 minutes.
I'm gonna give it to you for a second. Skittles, I had a case involving Skittles. The guys developed this Skittles cultivar with Z's. Got sued by Wrigley. Wrigley took 10 years to finally get around to suing. And then it turns out that we ended up settling the case and we stopped using Skittles with Z's, but we call ourselves the original Z now. But an interesting thing that I wanted to mention is cultivars and varietals are not trademarkable. Okay, so the Patent and Trademark Office would come back on the Skittles situation or similar to that, they would say, Skittles, even if you intended for it to be a mark that identified you, that you developed goodwill in, and that you identified as a brand that you developed that's unique to you, that we're not going to recognize that as something that's a trademarkable name. So when you think about it, so Skittles, Wrigley owns Skittles, they really don't have any rights under any circumstances relating to identification of some weed as Skittles cultivar. So if you have a jar on your shelf and in your dispensary and it's got cultivar, it's got Skittles with Z's on it, Wrigley doesn't have any claim there because it's referring, it's naming and referring to a cultivar and not a brand. So hopefully that was helpful.
No, that's fine. We're right. Okay. Yeah, it's boring. What I'm about to talk about. It's boring and
Oh, wait, I didn't introduce you.
corporate intensive.
You gotta
Yeah.
introduce Dana. Dana Cisneros is the founder of the cannabis corporate law firm, a boutique business and real estate law firm representing a wide variety of individuals and companies throughout California. The firm was founded with an eye towards diversity, compliance, and legality from the outset to further our clients' interests and avoid complicated legal and critical issues in this complex, highly regulated industry. The cannabis corporate law firm offers a wide variety of business and real estate legal services, conducting due diligence, handling complicated transactions, as well as associated land use, transactional, and compliance matters. They're a member of NCIA, the Minority Cannabis Business Association, the Esco Cannabis Bar Association, and the California Bar Association, et cetera.
etc. Take all my money. Also, I should also say that my firm was honored to receive the #2 spot in all of Orange County amongst all firms by the Register this year. So that was pretty cool that a cannabis firm got that. And with all love to Rattan Tucker, they were #3. Just saying. I am here today to talk to you about the Corporate Transparency Act, which is took effect on January 1st of this year. It was passed in 2021. We'll get into that in a minute. The materials that are provided for you, when you see things like this should be a clickable link, but there we go. There's the little hand. When you see underlines on the materials, that means that's a link. So this is a direct link to the act. And I can point out those things for you as we go along. As practitioners, because this is such a new law, I strongly recommend that you consult with it regularly and do not substitute this presentation for your own research and understanding of the Corporate Transparency Act. But it is relatively straightforward until we get to the exceptions. And that is what I'm going to spend some time on. It seems to me that every law firm and their cousin has put out a CTA presentation, fact sheet, something in the past few weeks, because this is a new act, because of its broad sweeping effect. And so I wanted to dive in a little deeper on some of the things that I think are important to our cannabis businesses as legal practitioners and folks that are tuning in as people that want to know as much as the lawyers in the room know. So the history of the Corporate Transparency Act, as I mentioned, it was passed in 2021. It is an anti-money laundering statute. And it now requires US and certain foreign companies to disclose information about their beneficial owners. I'll make this comment throughout the presentation, but the word beneficial owner should be setting off everybody's spidey sense in the room that does anything to do with cannabis licensing, because we know that owner in the state of California does not mean owner. It means anyone who manages, directs, or controls a portion of the business, and includes your C-suite as well. And that is indeed what this federal rule is driving home at. So this is something that we've seen before. This is something that our California cannabis companies already somewhat comply with. So as practitioners, it should not be too difficult for us to achieve compliance on behalf of our clients, or to work with their compliance departments to become compliant with the federal law that just has taken effect. FinCEN is the regulating bureau in the federal government. This is a bureau, not a department, but it is the Financial Crimes Enforcement Network, and its job is to it derives its authority from the Bank Secrecy Act and from the Secretary of Treasury, who appoints these folks. And their job is to monitor financial crimes. And so we will be registering with them online. My firm has already completed the process for my law firm. And I did that so that in coming here to speak to all of you, I would be assured that I was familiar with the process, as it did just open on January 1st. I'm the only owner, and I don't care that the federal government knows that, so it doesn't matter too much to me. You'll see the rules, just like we have here in California. We have statutes, and then we have regulations. Federal government has rules that interpret their statutes, and you can find this 31 CFR 1010. This link right here is again a hyperlink, so you can read the actual text of the rule when you desire to do that. It's kind of lengthy. I want to say it's about 82 pages, quadruple columned. Who has access to beneficial owner information? And you can go ahead and read through this, but essentially it is supposed to be held confidential and not disclosed except as authorized by the CTA. And here we have a list of who FinCEN is authorized to make disclosures to. Federal agencies, state law enforcement agencies, usual suspects. I would imagine that a lot of our clients are going to take issue with this, especially those that like to sit behind well-woven corporate webs in our fellow states such as Delaware and Nevada. This will be interesting. And my suspicion, if not understanding, is that it is because of folks hiding behind shell companies that prompted the need for this new law and this new compliance and disclosure of beneficial owners. Another interesting one is financial institutions who use beneficial owner information to facilitate compliance with customer due diligence. This was interesting to me in light of the SAFE Act and in light of Congress's and most folks' opinion that the banks need to come to the table at some point relatively soon. And so I think that this is very interesting to me. It will be interesting to see how these two things play with each other in terms of beneficial ownership information and reporting. If the banks will be able to rely on self-reported information, or if the banks have some enhanced diligence to engage in. So in any event, those are some fun things to talk about. You can click here also to learn about each agency and go more into detail about the security requirements and other information. Financial institutions are, in fact, as I just mentioned, subject to due diligence. This is in line with what I was just suggesting, but I bolded the important pieces which indicate that we are looking at perhaps financial institutions relying on this information. So there is a lawsuit. I don't know if Tim's involved.
No.
He says no, but
So
I don't.
is there a threshold for companies that have to do this?
Yeah, so we'll get into who's
Okay.
the beneficial owner and what's required, but largely it's a 25% threshold here in California, 20% threshold.
But as far as the size of the company?
Yes, there's exemptions for that.
Okay.
So we'll get there. So right now, the National Small Business Association, which is suing the Department of Treasury for implementation of this act, seeking to prevent the act from taking effect and moving forward. There was oral argument at the end of November, and we'll have to see what happens. Essentially, their arguments are it infringes on state sovereign powers over formations of companies, that it does not regulate commerce. It rather it imposes obligations on states and state entity filers, which we'll go into in a little bit, but the big trigger is the Secretary of State filings for who actually needs to report under the act. The CTA's application if essentially is to every business absent an exception. And then there's an argument for infringing on individual rights of privacy, which I imagine is going to be the hottest issue for our clients in the cannabis industry, and also the disclosure of sensitive personal information. And they're arguing that it's unconstitutionally vague because applicant and beneficial owner are used within the act. I don't buy this because I'm going to be able to tell you pretty clearly the difference between an applicant and a beneficial owner in the context of this presentation. But this is very interesting to me, and we will see what sort of analysis the court comes down with. This will likely set the tone for a lot of different cannabis issues moving forward. Reporting companies. So who's required to report? Nearly every small company in the United States is a potential reporting company. FinCEN did a great job of putting together this little flow chart. Essentially, If your company has filed a document with the Secretary of State to be created, then your company is a potential reporting company. Similarly, if you are operating a foreign company that has domestically registered with a Secretary of State, then you also may be a reporting company. The reason why we're saying maybe a reporting company is because they gave us a gift. I know. That is the exemptions. There are 23 listed exemptions to the Corporate Transparency Act, and I am not going to bore you by talking about every single one of them. Everyone listen, this is a screenshot of it placed into my presentation. This is contained within the beneficial owner information small entity handbook that is linked in the presentation, and you can find this information in detail there. But again, my job today was to semi-summarize this and analyze it for you. So I'm going to go into a couple of those, but it's really cool what they do. As you can see, let me see if I can make this any bigger. There we go. This is just an example. I picked broker dealer because I think broker dealer is really simple for everybody in this room to understand. We know what these people are. These are our Wall Street guys. And so they're exempted from the act. Big surprise there. But FinCEN was really nice to us and gave us these really pretty checklists. So you actually can sit down with their clients and go through the exemptions with them and determine whether or not the particular exemption applies to them. They've hyperlinked the codes and everything for you. So if you need to, do further research on the exact statement of the law, you can do that. But I am going to go in depth a little bit about the exemptions that I believe are most likely to apply to the folks in this room and paying attention via Zoom. So one is the securities reporting issuer, which we also know as public companies. Publicly traded companies are exempt if either of the following apply. They register under Section 12 of the SEC Act, or they're required to file supplementary periodic information under 15D. They must be exempt, must be registered with the SEC to be exempt. If you have clients who are either publicly traded companies or owned by publicly traded companies, pay attention for what happens with their beneficial owners. Number 10 exemption is investment companies and advisors. So these are folks that are primarily engaged in the business of investing, reinvesting, owning, holding, or trading securities. Again, must be registered with the SEC to be exempt. The link here will take you to the SEC's website to search yourself to determine whether or not a client might be falling under this exemption. But these are your mutual funds, EFTs, closed-end funds, and numerous other investment vehicles that folks use. Investment advisors are the folks who actually manage these funds, plan the funds, asset managers, hedge fund managers, equity firms, things of that nature. And again, you can check their registration here. And again, keeping in mind that just the fact that someone may do these things does not give them the exemption, but they actually do have to be registered in order to qualify for the exemption. And the reason for that, I think, makes sense because what's happening is they're gathering information about these people. Well, if you are already one of these people, they have your fingerprints on file and a whole boatload of information on you. So they understand that it's going to be unnecessarily duplicative and onerous. You're likely not laundering money. And if you are, they probably already have tapped you and paying attention. Just kidding. I don't know that at all. But VC fund advisor exemptions, under Dodd-Frank, the VC fund advisors can advise only venture capital funds, so they're not operators, they're advisory. They're acting in their advisory capacity. So those requirements are listed here. And I just wanted to give you some examples. I did dig in a little bit to give you guys just some more real world examples. So we have VC firms, boutique advisory firms, some family offices that exclusively manage VC funds. So most of the family offices that I'm aware of dabble in both. So they will manage funds, but they also have decided to operate, not to mention who knows how twisted financing is. Now that we're 5 and 6 years deep, who knows who's, foreclosed on interest, which notes have been converted and all kinds of things. So the corporate folks, we have our work cut out for us, to say the least. I might have accidentally duplicated that one. Pooled investment vehicles. This is essentially when some of these other listed exemptions get together to do investments together, and they will be identified on the ADV form filed with the SEC. And they also must have advised one of these exempt entities such as banks, credit unions, broker dealers, investment companies, or VC fund advisors. So, and then finally, what Tim was asking about the large company exemption, more than 20 full-time employees must be employed in the United States. They have an operating and physical presence in the United States, and the tax returns reflect more than $5 million in gross receipts or sales excluding receipts from outside the United States. And this will also, so for the $5 million threshold, it will also include entities that are filing under consolidated tax returns. I wanted to make a distinction because the rule for 5 million applies, for consolidated, for counting consolidated entities or conglomerate entities or vertically integrated companies that may file on a consolidated return. The $5 million rule will allow you to count the revenue of other entities. However, the head count for employees cannot be used as a factor across all companies. So each individual entity needs to employ 20 people, which is also interesting since that happens to be our threshold in California for executing a labor peace agreement. So these are not new numbers to us. Things should be looking familiar to everyone. Beneficial owners. And this is where things start to sound really familiar. Just like here in California, where a cannabis business is an owner, has a broad sweeping definition that includes other people. The CTA defines a beneficial owner as someone who directly or indirectly owns or controls at least 25% of the interests of the company or exercises substantial control. Substantial control includes senior officers, authority to appoint and remove officers or majority of directors. So you may have like founders involved or folks like that, or separate classes of shareholders that can make other decisions that have super voting rights, important decision makers, and any other form of substantial control over the company. Again, the SEC prepared some detail about that. This is again in your beneficial owner small business compliance guide that I've linked. And you can go over the exact details of all of this here. I'm just trying to make sure that we have, we get through everything, and then also that we have time if there's questions. Ownership interest can take on a myriad of forms. Please, for the love of God, if you're a layperson, talk to your lawyer about this. But equity stock, membership interest, etc. I do want to give a quick caveat. Trustees of a trust, maybe just this one's not updated. I did add a qualifier there. Trustees of a trust, when the trust has to be filed with the Secretary of State. If you recall back when I first started talking, the trigger point for most of these for compliance is going to be filing a document with the Secretary of the State. I am not a wills and trust attorney. However, my understanding, and if anybody wants to correct me or confirm, please do, but my understanding is that the state of California does not require trusts to be registered anywhere. This is it. Do you think that too, Tim?
I believe so, yeah.
Yeah. I looked it up. That's what my initial research said, but that is not even close to my area of expertise. In fact, I did not take the course in law school, so I am probably the least familiar.
I haven't registered my family trust, so I.
So, and that's the thing is I think our familiar connections with trust, but if anybody's a trust attorney, let us know. Okay. So we have all kinds of folks, so this is my summary, but again, FinCEN did a nice job of putting together a pretty little chart for you that I'll leave to each person to examine more greatly in depth. But it just describes different types of equity or ownership interest that may trigger the need to make a disclosure under the CTA.
So what if your client just happens to forget to declare some investors that would arguably fall?
Well,
into it?
it's a great question for at the end of this presentation when we discuss enforcement. Seems like every boss I ever had that reads my work and is like, oh, but what? Yeah, just keep reading. Hold on, just stay with me. Okay, the reason why I wanted to point out that FinCEN gave this example of I think, not too complicated, ownership structure, something we're probably fairly likely to see, in a cannabis business. Like Tim had described, we tend to try to separate ownership of assets, to insulate liabilities. And, here, I just wanted to point out that if you do the numbers, so if like this guy here who has 30% of company Y, which has 50%, if we did the math, that means individual A would have 15%, but wait, there's more because he also owns 25% of company Z. So that 15% plus his 12.5% comes to 27.5. That's more than 25%. Individual A actually has two different portions of ownership. He is an individual that needs to be reported, or she or it needs to be reported. So just again, this just goes to back to my point. Us corporate lawyers have our work cut out for us. If nothing else, it's a good time to revisit your corporate structures with your clients and see what's changed, if anything, since the last time you all talked. And yeah, so exceptions to beneficial owners, minor children, the parent will be disclosed. If there's nominees, intermediaries, custodians, or agents, those folks are not disclosed. Employees, except for the C-suite, like I explained, and attorneys in the room, general counsel. If you are general counsel, you are considered an important decision maker. I personally believe that this is applicable to in-house general counsel. I do not think that practitioners like myself that sit as outside general counsel would qualify, because I can promise you that I have absolutely no control over what my clients do. In spite of how much they pay me, they often don't listen, and I can promise you that I have zero control over what happens once decisions are made by the folks who are supposed to be making those decisions.
Unless you're not an employee.
I'm not an employee, but there's, well, this is not an exemption, this is an exception. So employees who are not these people.
Okay.
Because we can have presidents, CFOs, CEOs, COOs who actually are not directly employed by the company. Okay, heirs, if the interest is a future interest in the reporting company, and creditors, they are not required to be disclosed. Company applicants, so this is important for all of us to know, that our attorneys, because the trigger date is January 1st. So if the entity was created and in existence prior to January 1st, 2024, then I'm saying this backwards. If it was created prior to 2024, we do not need to report the company applicants. If it is created on or after January 1st, 2024, the company applicants do need to be disclosed. These are the people who do the actual filing of these reports with FinCEN. So these company applicants are only individuals. They are not entities. They are not corporate reporting services, CCT systems or whatever up in here. All companies created on or after January 1st, 2024 must have at least one company applicant. Lawyers, tax professionals, and other agents likely are company applicants. So we are going to end up as the company applicant likely for many of our clients, unless our clients do the filing themselves. keep in mind, this does not make us beneficial owners. All this means is we're paper pushers, just like we are right now, signing things for court. I personally was a little bit concerned at first. I have not so much concern anymore now that I've sat with this information for some time, because I do believe that it is akin to what we do when we file documents with the court. We are simply representing someone else's interests and assisting them in securing rights and compliance, and that is indeed the practice of law. Direct filers are the human being who actually pushed the document through the system. This would be the individual who files, and then the indirect filer is the person who provides the information to the direct filer. You can also register for a FinCEN ID. So if you have clients that own 60 companies, you may want to consider registering them for a FinCEN ID so that that information can be populated every time, as opposed to individually completing the beneficial owner information each and every time. Registration and filing. I have some checklists here, but it's pretty light. It's your legal name of your entity, any DBAs, your US address, and foreign companies list their US based address, state tribal jurisdiction of formation. So wherever you filed with the Secretary of State, that's where you're going to list. And then you need your EIN. And only if you do not have an EIN may a foreign tax identification number be used. For beneficial owners, you need the legal name, date of birth, resident address, and you also have to upload a copy of your identification, which is kind of creepy. I heard a ooh from Dale in the background. But nevertheless, you are going to have to put, I uploaded my driver's license. So like I said, I went ahead and completed this process because I wanted to understand what exactly what we're looking at. And I did have to put my driver's license in. This is the deadlines. So right now, companies formed prior to January 1st of this year have all the way until January 1st of 2025. If you think that the National Small Business Association may be successful in their lawsuit, you may want to have a conversation with your clients about delaying reporting. I don't think anyone but me was eager to go jump on the system and go through with the filing. And again, that was largely because of this presentation. Companies who are formed on or after January 1st, 2024 will have 90 days from the, and there's some interesting language in there, but essentially what it gets down to is the actual or constructive public notice that the Secretary of the State has accepted your filing. So basically, if you pull your articles off of the internet, whatever date that is probably a good rule of thumb. If you have a funky date for some reason, your lawyer should know what they're talking about. If not, call someone who is a well-versed corporate attorney. Companies created on or after January 1 of 2025, so next year, are going to have to file within 30 days. Where to file online? This is just a screenshot. It's really simple. I gave you right here the link, so it'll take you right to it. And you can just jump on here and get going. It doesn't take very long. It maybe took me like 5 or 10 minutes. I think the biggest challenge I had was locating my tax ID. And that was about it. But again, we have checklists. I provided you with checklists. So you should be able to do like a quick and easy client intake questionnaire and be off to the races. Updated reports are due 30 days after a change. And that is something everybody should be cognizant of, about changes that are being made this year by your entities that were formed last year. You are likely going to trigger a reporting requirement. And enforcement and penalties. So there is a safe harbor of 90 days for errors in the report if you voluntarily file an updated report. So if somebody forgot and then later you find out, you voluntarily find it, they're not going to do anything to you for 90 days. There's issues for the willful violation or fraudulent submission of ownership. It's $500 a day for each day and a fine of up to $10,000. Senior officers themselves, if they want to mess around and find out, they can, but they're gonna be on the hook too.
That looks nasty.
It's pretty, yeah. Yeah. I mean, go figure. They don't want money laundering.
What about the lawyer that gets it wrong? If the lawyer's the agent that's filing it, what if the lawyer forgets something? What if you don't, and then maybe it's
Have some
through
insurance.
negligence on the part of the lawyer, not having an adequate checklist to go through with the client.
I think there's a word for that. It starts with an M. It shall not be spoken in these halls. I'm just kidding.
So do you think that'll get developed in your practice as far as people get like a gold standard for a checklist for?
Yeah,
going through
it's
the client?
like I said, the process is super straightforward. It's like literally like, what's your name? What's your address? And for most of us in California who have interacted with the licensing system, we already have this information. We should. The state lately has been asking for it even when we don't have to report people. So I have clients who have 53% ownership of folks that qualify as financial interest holders or owners, depending on their ownership percentage, and a boatload of people who don't qualify at all, like fractional interests, people's kids, whatever. And the state has recently come to me like, where's all the rest to make 100%? And I'm like, I don't have to tell you, that's not part of the rule anymore. So, so there is enforcement, but nevertheless, if your company was formed or your client's company was formed prior to January 1st, you have until the end of this year, and you may want to sit and see what happens with, the lawsuit.
Okay, for our clients, I didn't mean this to be an interview, but for our clients that have let's call them secret partners again, where we've got people that may be in sensitive industries elsewhere, like I've got a case where a client, one of the people that are involved is in the gaming industry. They don't want their name on anything.
Yeah, fucking sucks.
Is it gonna flush these people out?
Yeah, this is the
Because
entire
there's
point.
it's a federal
It's a federal
penalty.
law. It's a federal law.
To the
So
extent that
importantly,
you could have skirted the California system because they don't have the
Delaware.
resources. Or any place that had the resources to track down every beneficial owner or financial interest holder. Now you have the federal government that's got this regulatory scheme with a serious enforcement fight.
yeah.
Okay.
But again, like Tim just pointed out, it's important to remember and to know this is not directed just at us because we're cannabis for once, thank God. This is everybody, and that's why one of the earlier slides was this touches on essentially every small business in this country. And I think that's really the beef that the National Small Business Association has with this is why the hell are we picking on the little guy? Like, this is like, I don't want to get like too preachy, but I think I saw a meme like, we have corporations not paying their taxes, and meanwhile, they're trying to squeeze the lady that knit a sweater for her friend down the street for the tax on the $20 she sold it for. It's like we're barking down the wrong path. But I want to answer some of these questions. So Canada stats do nonprofit corporations also need to file this information? No, you are exempt. That's in the 23 listed exemptions. Sorry, not a corporation organization. Yeah, you should talk to your lawyer, Candace. Because I am a Cisneros legal advisor. I'm just joking. And then Chernus asked, how much work is involved in the CTA filing? Chernus, I would say, I mean, if you want to know like billing, I would say 0.3 to 0.5. That's what I would think. It took me, I mean, it just depends on the size of the company. And it probably depends on how much pushback you get from your clients and how applicable the exemptions are. There are a lot of exemptions, but really do jump into that that small business compliance guide, because like I said, up here, let me see if I can get back up there quickly. But there's really cool little just boxes, and it's pages and pages of these boxes for each and every one of the 23 exemptions on what to ask, where to look, what to go through, what the applicable laws are. So it's extremely helpful for us. Okay, and then Candace is saying disregard, and I just answered Chernus. So I think, do I have any more? Do I say done? Is that all the questions? Does anybody, Lauren, do you see any more questions? Lauren still does.
I'm
not
still
able-
here. One second. No, I think that I believe you got to all of them that are relevant to this
I
one.
think it, does anyone in the room have questions?
I had a comment, just a
Oh, we all
comment.
enjoyed this lovely presentation.
I thought it was interesting that there's an exemption for large companies and not small companies.
Right,
Sometimes
this is
there
actually
are,
directed at small companies.
yeah, so I mean, could you maybe speak to why you think there's that exemption?
Because just like, this is my thought. I think there's opinions about it. I did come across this when I was like researching the presentation. So I think it, it's an opinion, but, I believe it's because the regulations applicable to larger companies are more stringent. And so as a result, they are not subject to this beneficial owner requirement in the same way. I do also want to comment on the $5 million threshold. In any other world, that's a pretty significant threshold for gross receipts. In cannabis, it's not. $5 million is not that much money through the vertical, to be honest. So really pay attention for those exemptions because maybe your clients want to hire a couple more people to fit neatly into the exemption. It's a strategy. It's going to be a strategy if they care about these disclosures. It's definitely going to be a strategy conversation to have with the
You
attorneys.
really gotta cut this.
We're good.
out. Yeah, very good, Dana. And Tim, thank you so much.
Thank you, Dana.
A little break scheduled, but I think we're gonna kind of try and push on, come up Ron, but we're gonna take a minute and make sure I get Ron's. And moment to stretch and we'll get started with Ron and Bill.
Size tax gross.
So where did we put that? I want to make sure
Where?
it comes up full
Where?
screen instead of all this nonsense we've been
For the
getting.
excise
We
tax
just had to go to a
credit,
PDF with her. It's coming up with like a
That says
presenter view and I can't seem to get rid of that.